Inheritance of funds in a deceased person's bank account. When someone passes away, one of the most common questions is what happens to the money left in the bank and whether the account can still be used. Although, from a legal standpoint, assets pass to the heirs at death, that does not mean family members can freely access or withdraw funds right away. In practice, banks require proper estate administration before releasing significant funds or transferring rights in the account. Being a child, spouse, partner, or relative does not automatically grant access to the account balance. As a general rule, the bank will require appropriate estate documentation depending on the case. This may include probate proceedings, court orders, or other formal authorization. Banks act cautiously to avoid improper payments and potential disputes among heirs. Power of attorney. A common misconception is that a power of attorney remains valid after death. It does not. As a general rule, a power of attorney becomes invalid upon the death of the person who granted it. Anyone who previously had authority to act on behalf of the deceased no longer has the legal right to access or manage the account. Joint accounts. The situation can be more complex when there is a joint bank account. Many people assume that the surviving account holder automatically becomes the sole owner of all funds. That is not always correct. While a joint account may allow continued access and operation by the surviving account holder, this does not necessarily determine ownership of the funds. The legal treatment may depend on how the account was structured, such as whether it included rights of survivorship. Even in cases where the account allows continued access, it is important to distinguish between the ability to use the account and the actual ownership of the funds. If some or all of the money belonged to the deceased, it may still be considered part of the estate and subject to probate and distribution. In other words, access to the account does not necessarily eliminate potential disputes among heirs. Negative balance. Another point that often causes confusion is the existence of debt or a negative balance. Not all debts are automatically the personal responsibility of the heirs. In general, debts are handled through the estate, and liability is typically limited to the assets of the estate itself. Each situation must be carefully reviewed based on the overall financial position of the deceased. In summary, having a will or organizing your estate in advance is not excessive. It is prudent. Lack of planning often leads to delays, additional costs, and unnecessary disputes during an already difficult time for the family. Proper preparation can prevent complications and provide greater certainty for everyone involved. For questions or specific situations, you may contact shimbrumegmail.com.